Litigation expenses are expenses that are accrued and booked when they happen. They reduce the bottom line, they reduce net income, but the asset, this contingent litigation asset that they have, by and large, can't be booked as an asset on the balance sheet. And even if there is some sort of revenue that's received from this litigation in the future, it's going to be a below-the-line revenue, other income that investors and people valuing the company generally don't count for much. So what litigation finance can do is it comes in, takes those expenses off balance sheet, raises net income, and allows them to pursue these litigation assets without hurting their bottom line. Third thing here is obtaining lower cost of capital. We found that in some situations, claim holders may not have good options for access to capital, and we can provide a lower cost of capital than they otherwise would be able to achieve. Hedging the risk of litigation. For those of you, I don't know how many of you in here are lawyers who have been in a lawsuit, but litigation is inherently risky. You could have the best claim in the world and you could still lose. And so what we do as litigation funders is we are in the business of taking some of that risk away from you. So you can offload some of your risk, have a bird in the hand now, still maintain some of your claim and maintain some of the risk that you want, but then hedge your bets a little bit. We're there to be the counterparty for that transaction. When a law firm is the counterparty, there are some special benefits that come into play. One of those is just maintaining or decreasing law firm volatility. If you're a plaintiff side firm that does primarily contingency type cases, your fees may be lumpy. You may get a big hit in January, a hit in May, big hit in December, but you got to pay your staff and your lawyers every month, and you've got to pay your rent, you got to pay your overhead. And a litigation funder can come in and take that time risk away from you, give you certainty of money for a specified period of time. You can draw down on that money, and then the litigation, you can still have some of the upside, and then the litigation funder takes away your time risk. And finally, I think that litigation funding can create arrangements between clients and law firms that they otherwise might not have been able to do. A client may really want to hire a certain lawyer, but he wants that lawyer to do it on a contingency fee. But the lawyer wants to do it by the hour. So in a situation like that, a litigation funder could come in and contract with either the claim holder or the lawyer so that everybody's happy. They could contract with the claim holder so that the claim holder can pay the lawyer by the hour but doesn't have any out-of-pocket expenses because the litigation funder is doing that. Or the funder could work with the law firm on the back end to offload that risk that they don't want with a contingency fee arrangement. So where is litigation funding used? So I am engaged primarily in complex commercial litigation with cases with damages generally in excess of $20 million. That's only one part of litigation funding, is complex commercial litigation. That's business torts like breach of contract, breach of fiduciary duty, misappropriation of trade secrets, things like that. But it's used really across a whole swath of litigations domestically and internationally. There's arbitrations, domestic and international arbitrations, bankruptcy litigation, IP litigation, patent infringement cases in particular have historically been a fertile ground for litigation funding. Portfolios, I've talked a little bit about this already on the law firm side, that there's funding of law firm portfolios of cases, but it's also becoming increasingly more common that corporations seek funding for a portfolio of their claims. They could have a number of claims, 5, 10 affirmative claims, and they seek financing that's secured by that portfolio of affirmative claims. And then last year is consumer litigation. So as I said, I'm engaged in commercial litigation, so I'm definitely not an expert on consumer litigation, but it's been around a little bit longer in the US than the commercial litigation has, but there is a robust consumer litigation finance market. The funded party is usually the claimant or a counterclaimant, somebody who has an affirmative claim. But as I will speak, this is just a teaser, as I will speak much more in depth later, defendants are finding new ways to use litigation finance, and we'll go into that in more detail. So, what are the typical investment structures? How does the litigation funder get their returns? There's really every investment is bespoke, and we come up with a different arrangement depending upon the counterparty and what they're looking for. But these are some typical ones. Multiples. So we disperse $10 and then we're purchasing $20 from the proceeds. Percentages. We disperse $10 and we get 10% of the proceeds. There's typical interest rates that you'd see with a normal loan. There's equity. So there's times when the thing that makes the most sense is that we actually purchase a portion of the company, a portion of the claim holder. And there's future revenue streams. Sometimes there's an asset at issue in a case that is a revenue producing asset. And part of the returns to the litigation funder can be that the litigation funder funds part of the lawsuit but then has rights to revenue from that asset going into the future if the litigation is successful. I imagine we're going to get into this a little bit more later, but for those of you who would be users of litigation funding, just very basics on what the typical underwriting process looks like. Generally, somebody would call a litigation funder. We would make a quick determination as to whether the opportunity fits in our wheelhouse. Is it too small? Is it too big? Is it the type of case we look at? Assuming it does, we would quickly get under a non-disclosure agreement and then schedule a broader call to really get into the details of the case, to understand the facts, the law, the narrative. Assuming it's the type of case that we think we would want to move forward with, we would put out a proposal for the terms. People come to agreement on that, and then the funder would dig into due diligence, where they're going to look at the documents and the transcripts, look at the case law, and just to get a firmer grasp on whether they think this is something they want to move forward with. Assuming they do, they paper the transaction, and then as I said, the funder doesn't have any settlement control, but the funder generally monitors the case and talks with the claim holder and lawyer over time about how things are going. I would say one of the most common questions that we get from lawyers are questions of privilege. Is if they're giving documents to us, are those discoverable? So there's obviously two different ways of protecting documents. That's through attorney-client privilege and attorney work product. We don't want attorney-client privileged communications between lawyers and their claim holders, because although there is an argument to be made that the disclosures are privileged, the case law is generally not supportive right now, and so we don't want them. But the case law is generally supportive of work product protection, so long as there's a non-disclosure agreement in place. Although there are some cases that go the other way, we've seen that most cases are finding that there is work product protection. So is litigation finance legal? That's for those of you who are lawyers, you might have learned in law school about champerty and maintenance. It's an old English common law doctrine that was made in the context of feudal lords who would feud against each other and then fund lawsuits to be vexatious to their rival feudal lord. And so there was this common law doctrine that made that illegal, and it was called champerty and maintenance. As a general matter, it has to be looked at on a case-by-case basis. Some states never adopted champerty from the English common law. Some states adopted it but have since rejected it, either through statute or case law. And in other states, it may still be applicable. So it just needs to be a case-by-case analysis. And as I already said, the litigation funder is a passive investor. But we do monitor the case, and litigation counsel and the claim holder can use us as a sounding board, as a independent third party who has views on the case and sees cases all the time, who might have some insights into the case. So those are just the basics of litigation finance, kind of the past. Now I'm going to talk about the present and the future of litigation finance. The awareness and use of litigation finance has grown exponentially in the last few years. Just the number of news articles you see, conferences like this you see, are far more, you see them far more than you did in the early 2010s. I'm seeing news articles on litigation funding in The Economist, The Wall Street Journal, things like that. I've seen surveys showing that somewhere between 35 and 40% of U.S. litigators have direct experience with litigation funding. And Lake Whillans conducted a survey of U.S. in-house counsels that suggests around 26% have direct experience with litigation finance. So there's obviously a lot of room to grow there, but that's a lot more than the negligible amount that was used 10 years ago. Burford Capital, which is another litigation finance, a commercial litigation finance company, did a survey, and they found that 70% of lawyers who have not yet used litigation finance expect to do so within 2 years. So the rate of growth for these numbers, for those who have direct experience, will likely grow even more as time goes on. So there's increased demand and awareness for litigation finance. Then the question is there increased supply? And the answer is yes. It's hard to get hard and solid numbers on this, but anecdotally and through various news websites I've seen, there are billions of dollars of additional capital flowing into litigation finance. Capital sources generally like litigation finance because the returns, at least to date, have been very good, very high returns. And the returns are generally uncorrelated with broader market swings. And in times of volatility, like we've had recently, it can be particularly attractive to capital sources. And not surprisingly, because all this capital is coming into the industry, you see new litigation finance companies that are popping up as well. At Lake Whillans, at least, we continue to see a lot of opportunities coming to us from claim holders and law firms and brokers, but we're seeing more opportunities really than we ever have before. And that mix is changing a bit too. We're seeing more large corporations, and it's an ever-evolving mix as it becomes a more common practice and more people are aware of it. So a few recent developments in the ethics of litigation finance. These have all happened within the last 12 months and are still hot topics. Portfolio funding of law firms, as I just discussed. Portfolio funding has been, there is a model rule, for those of you who are lawyers, you may know this, there is a model rule of professional responsibility, Rule 5.4, which states that a lawyer may not share fees with a non-lawyer. The New York Bar Association recently had a ruling saying that, or they issued an opinion saying that portfolio funding of law firms on a non-recourse basis violates Model Rule 5.4. This was obviously controversial amongst the litigation funding community. Most of us disagreed with it. The New York City Bar Association has recently constituted a committee and a working group to talk about litigation funding and to learn more about it. They said they were not going to revisit their opinion, but there will probably be more to come from the New York City Bar Association. So that's just the New York City Bar Association. Most city and state bar associations have generally been silent on the ethics of portfolio funding of law firms. And most courts who have addressed these agreements have generally enforced them. There are some bar associations which have found certain types of portfolio funding to violate Model Rule 5.4. Just a few of them have said that, for example, taking a straight percentage of a lawyer's fees might be suspect, or that funding only one case rather than a portfolio of cases might be suspect. But as a general rule, if you're looking for litigation funding, you need to look at the ethics in your relevant jurisdiction to see what the rules are. Disclosure. Disclosure is probably the hottest topic in the ethics of litigation finance right now. The question is, does a person using litigation finance need to tell the other side that they're using it? Obviously, as a general perspective, people who are more often defendants want disclosure. There's generally no current rule that requires disclosure, but there are some exceptions. The first is Wisconsin. Wisconsin is as a general matter, if you're using litigation funding in Wisconsin, it needs to be disclosed. There was a law signed by Governor Scott Walker in early 2018 requiring that. And it is, to my knowledge, the most expansive disclosure requirement in the country. Otherwise, you need to check your local rules, because local rules might have rules which could require disclosure of litigation funding arrangements. I think likely the most on point is the Northern District of California, which requires the disclosure of litigation funding arrangements in class actions and MDLs. A few recent developments for those of you who follow the ongoings in the Senate. Senator Grassley recently introduced a bill which was previously introduced in 2018, but died in the Senate, but was reintroduced recently, requiring the disclosure of litigation funding arrangements in class actions and MDLs. So I don't know where that'll go, but the Senate will debate that soon, and then we'll see if it goes to the House and then President Trump. But that's something to look out for in 2019 is that law related to disclosure. Furthermore, a number of corporate general counsels have recently written a letter to the Federal Rules Committee asking that there be a rule change such that under the federal rules, in any case, there needs to be an automatic disclosure of litigation finance arrangements. There was an opposing letter from some litigation funders saying that that shouldn't happen. We'll see what the Rules Committee does. They've looked at this issue in the past and have generally said that it's not ripe yet, but they're going to consider it again this year, and we'll be watching that. And then finally is the opioids MDL. Judge Polster in the opioids MDL required all of the plaintiff's lawyers to, in camera and ex parte, that means in the chambers away from the opposing counsel, to show him the litigation funding arrangements to make sure that there was no conflict of interest or that they hadn't ceded any settlement control to the litigation funder. So that's one way that one judge has dealt with this, and so we'll see if anybody else follows a similar tack. So, important considerations going forward in 2019 and beyond. As I said, there's more and more capital coming into the industry, and there's more and more providers of the capital that are sprouting up every day. So, how will funders differentiate themselves as new supply enters the market? I think there might be two that I'm thinking of right now. One is simply the reliability of performance by the funder. Funders will likely try and sell that, this is a litigation that can last 3, 4, 5. I've been in litigations that were filed in the year 2000, so they can last a long time. And so is the litigation funder going to be around for the entire litigation? Are they a reliable party? Are they going to have the funds when they need it? And are they going to perform under the contract? So that's one way that funders might try and differentiate themselves. The second is know-how, we're providing funds, but we also see hundreds, thousands of cases, and we see how these cases resolve, and so we may develop a particular know-how about valuation of cases and cost management of cases that claim holders and lawyers may find beneficial. So litigation funders may try and use that as a way of differentiating themselves from one another. And then the second thing here is new products and new users. There's more supply, will more demand be created, more sources of demand? And I think so, and so I'm going to go into a few of those. I teased you a little bit earlier about there being that I was going to talk about defense side funding, so that's what I'm doing right now. So obviously the traditional way of litigation funding is to fund plaintiffs, plaintiffs who need the money to prosecute their affirmative litigation. Intuitively, on first blush, it might be why would a litigation funder invest in a defense side case? Because they're not going to get any money. They're simply defending themselves from having to pay. There's really two traditional forms. I mean, these are main ones. There might be others. Two traditional forms and two emerging forms of defense side funding. The first traditional one is kind of a loophole. Is that if you're a counterclaimant. Counterclaimants are bringing affirmative claims when they're a defendant. So they have a valuable litigation asset where they could receive compensation or they could receive proceeds from that counterclaim. So they're really acting like a plaintiff. The second, and I touched on this earlier, is where there's a litigation producing asset that's at issue in the case. So a defendant might be trying to defend their ability to have distribution rights or to own a pharmaceutical drug or anything of that sort. And if they win the case, they get to keep it. And if they lose the case, they don't. So in cases like that, a defendant can be funded and the returns can be gained from revenue from that asset. And two emerging forms. First is portfolio funding, and that a claimant or corporation might have 5, 10, 15 cases. Some of those are defense side cases, and they're just paying the expenses, and that's something that's hitting the bottom line. But they also might have affirmative cases. Litigation funder can come in, fund a whole portfolio of cases, defense and plaintiff side cases. The claimant can use that money to pay for all those litigation expenses, and the funding is secured by the affirmative cases that are likely to get proceeds in the future. The second is what I'm calling here the defined outcomes model. This is, in my mind, a lot like after the event insurance, something that I've seen some litigation funders pushing forward within the last 12 months, which goes along the following lines. A defendant has a case where there is exposure of $100 million. The litigation funder comes in and says, I think that you have a good defense here. If you get hit for less than $50 million, we get some sort of specified return. The litigation funder would. If you get hit for more than $50 million, then we eat that. The litigation funder would eat that. So it's sort of like an insurance policy. So there's a lot of different ways that this can be done, but that's one emerging way of funding defendants in litigation. And then secondly here is, will usage by large corporations continue to expand? As I said earlier, kind of the traditional way you think about litigation funding is in David versus Goliath litigation, where you have some startup or some small company that was wronged by some huge company. They don't have the money to fund their operations and to fund the lawsuit, but they have this meritorious claim. So they go to a litigation funder who would provide them with the capital, and they would be able to enforce their rights. Large corporations, generally from that perspective wouldn't fit in. But as I said earlier, there's some benefits to large corporations to using litigation finance. Primarily taking the expenses off balance sheet, monetizing your litigation assets now, and allowing you to use that money to run operations, to make core operating profits, which are things that investors and shareholders care about. According to a survey by Burford, over 2/3 of lawyers say that their organization have foregone claims because of legal expenses. This is the point I was just talking about. Those legal expenses which hit the bottom line, reduce net income. And 59% state that they have outstanding legal assets of over $10 million that they haven't enforced. There is evidence to support this, that there are these claims out there that big, large corporations could bring and maybe will bring because of litigation finance. And as I said earlier, a Lake Whillans survey found that 26%, which is high in comparison to 10 years ago, but still there's a lot of room to growth, 26% of in-house lawyers have experience with litigation finance. So that number there's a lot of room for more corporations to use litigation funding for the reasons I just specified. And really it's kind of a shift in the way that corporations look at legal departments. They look at them as cost centers or as profit centers. They're traditionally looked at as cost centers. They're just trying to defend themselves from getting hit by big judgments. But looking at them as profit centers, ways of enforcing your rights to create revenue for the firm, is a potential development going forward for corporations, and litigation finance can be part of that. And then finally, as I've touched on this before, is the funding of corporation portfolios. corporations, big corporations who do business everywhere, they probably have a lot of claims. They have a lot of defense side claims, a lot of plaintiff side claims, and a new development is just the funding of the whole portfolio of their claims. They come to a litigation funder and say, I need this amount of money, and I'll give you the proceeds from all, it'll be secured by the proceeds from all of my claims. That's something which is relatively new, and we've seen some of an increase in, and I think it's likely to increase in the future. That ends, kind of my overview of the past, present, and what I see to be the future. We have a few minutes, 5 minutes. I'm happy to answer any questions, but I'm also happy for people to get up and get coffee and talk to one another. Yeah, Liz.
Hi, just a question, two questions actually. Earlier in your presentation, when you were talking about fees, so how would you go about truly securing an interest in fees? Because I kind of find it difficult as a senior banker.
So
UCC, perfection, and all the rest of it on settlement fees is not easy.
So we generally purchase the fees. It's not a loan. It's not like we're secured by them. I was using that kind of as shorthand. We purchase them. If there is a senior lender, such as Huntington Bank, we would normally try and enter into a subordination agreement.
Okay. And then that's helpful, thank you. And then my other question was more in lines with the New York City Bar Association opinion, which is definitely contested from a lot of our clients especially.
Right.
What I was wondering is, do you think the issue there is truly reliant on a conflict of interest associated with, a funder kind of trying to force a firm to settle and get the fee paid out quickly, which is not in the best interest of the class members? Is that really where you think this discord comes from?
That wasn't the reasoning that was used in the opinion. There may be some currents of that amongst some people. I would say I personally don't find that very persuasive, because I find in any sort of a case, whether a case is self-funded by the lawyer or funded from outside, there's going to be an interest for the lawyer or somebody to settle the case. But we rely on lawyers to comply with their professional responsibilities, not to settle a case because they've self-funded it and they have all sorts of obligations and it's their money at risk. When it's the litigation funder's money at risk, it really shouldn't change the analysis much in my mind.
Yeah, I guess I was just thinking from the standpoint of if undue pressure is being exerted either by a lender or a funder,
yeah,
to compromise the position or activities of the attorney, I have a feeling that's the undercurrent that's truly annoying people.
I definitely agree that I definitely agree that's a concern people have, and it may be the undercurrent here. It wasn't the way they articulated. They articulated it in kind of legalistic ways based upon the case law relating to Model Rule 5.4. But I take.
By the way, when you ask a question, if you don't mind, include your name and companies so people know who you are.
Oh, sorry. Liz Lambert, Huntington.
Todd Lee, Foreign Capital. The New York City Model Rule 5.4 ruling, does that preclude entirely pre-settlement funding in New York City cases, or does it just require a restructuring of the fee arrangement between the client and the funder?
Yeah, so whether it precludes it as a legal matter, I'm not sure that I can opine here on like whether it is an actual ethical violation. It's their opinion as to what the ethics, what would happen in an ethics proceeding. But no, it can be restructured in many different ways. First of all, the litigation funder could make it a full recourse loan, and then if it's full recourse, then it's not violative of that. And then also you could just restructure it so that you're working with the claim holder rather than the lawyer. So as I said earlier, litigation.
Just make your claim subordinate to the lawyer's fees, and then you're not sharing, or wouldn't that easily?
Well, because if you're working with a law firm, the only thing you're getting is from the fees. So it's not like you're getting. So if there's a $100 verdict and the law firm is entitled to a 30% contingency fee, you're only getting your returns from that 30%.
Got it. Okay.
Yeah. But as I said earlier, there's litigation funding can allow you to restructure any arrangement between a claimant and a law firm to any desired effect. So if we were working with the lawyer, what we could do is then we would work with the claim holder, and the claim holder would pay that lawyer by the hour, and then we would purchase a portion of the claim holder's.
It doesn't seem like that would have much teeth to it, given how easy it is to structure around.
I haven't seen much change in the landscape because of it.
Okay.
Joe, Regina, 400 Capital. Can you talk a little bit more about settlement control from litigation funders and what exactly a litigation funder means in that context? Because the way that I would think about this is the litigation.
You want there to be enough room between the amount that you've funded and what you think the value of the case is. Just as a general rule of thumb, in most cases, you want there to be kind of a 10-to-1 ratio of the value, the realistic value of the case and the amount that's being funded, so that all the incentives are aligned, so that the client is going to get will get a large portion of the claim, the lawyers are going to get paid, and everybody is going to accept a reasonable settlement if it's out there.
Got it.
Make sense?
So it's more of like a control of the litigation funder having like a debt-like interest in the claim versus, equity-like control, rather than some kind of, legal permissibility on whether the claim assignee can do stuff. Is kind of what I took from that. Yeah, right.
Yeah. I think that's right, but happy to discuss with you afterwards if you have more questions. Mark?
So I got a question. So in terms of the federal bills that are being passed in Congress, so what I learned is any bill that's against doctors or against lawyers, it's usually killed, right? It generally doesn't go through.
Yeah.
So the only way this is being pushed by Grassley is people who are behind it. So who are the protagonists that are against, I guess, litigation funding in this case?
As a general, I would say that the most vocal opponent of litigation finance is the U.S. Chamber of Commerce, who they have publicly spoken about it, and I don't know what what their involvement was with respect to the bill that was introduced into Senate, but that's really the most vocal proponent of opposition to litigation finance.
Would there be, in other words, there aren't particular parties, in other words, a pharmaceutical industry or something like that? I'm using that as an example.
Right.
But it isn't a case where a particular industries has a vested interest in this going through? Because that's the only way I see this stuff happening.
Yeah, no, I haven't seen any reporting or evidence that there's a specific industry that's particularly hostile to litigation finance. It just is a general matter. It's the U.S. Chamber of Commerce.
I mean, I guess it originally not originally, but it came about in strong force when Goodlatte, the Virginia representative, was totally gunning to, put class action out of business, so to speak. And then he's no longer, active. I didn't even realize that Grassley has kind of picked up the slack there,
Mm-hmm.
but it wasn't successful. It didn't pass through everything, and we're really hoping it does not.
Well, there was I remember a bill passed, I forgot how many years ago, you guys will know better than me, but there was a bill that did pass that changed the entire rule of class action, meaning you had to have 100 claimants in order for it to become officially a class action.
Yeah.
That bill did go through federal Congress, and that obviously, it was controversial, but it did get passed. So there were people pushing for that to happen. I imagine it was mostly, if you will, corporate America that was saying, hey, that's what we want.
Yeah. I think you're talking about the Class Action Fairness Act. I don't know who was behind that, but I mean, you're right that often there are proponents behind these that are pushing them to the senators, and as far as I can see, the most vocal is the U.S. Chamber of Commerce.
Why?
I think just there is a knee-jerk reaction from large corporations that they don't like litigation. They're often, large corporations are often defendants, and they see litigation as bad. It's a cost for them, and it's potential exposure. As I said earlier, we've seen more large corporations that have found the benefit of litigation finance, and based upon anecdotal things I've heard, lots of big Fortune 100 companies are using litigation finance, and so whether or not it's true that large corporations should be averse to litigation finance, that's how it's being presented right now.
Well, please thank Chris.